Today's presentation is being recorded and will soon be available for on-demand viewing on our website at bu.edu/alumni. Our speaker today is very eager to answer any questions that you may have, and you're welcome to submit them throughout the presentation using the Q&A box. If you hover over the top or bottom of your screen in Zoom, it'll bring up a menu, and if you select Q&A, that'll give you the opportunity to go ahead and type your question in whenever one comes up for you. It's now my pleasure to introduce our speaker for the day, BU School of Law alumnus Callan Stein. Cal's a partner in the Health Sciences Department at the White Collar Litigation and Investigations Practice Group of Pepper Hamilton LLP. He regularly defends corporations, corporate officers and directors, governmental and public employees, and other individuals accused of or being investigated for alleged white-collar crimes. His experience includes matters involving alleged state and federal False Claims Act violations, healthcare fraud and abuse, securities fraud, mail fraud and wire fraud, racketeering, and RICO violation of individuals during all stages of the criminal process, including responding to government requests for information that typically signal an active or potential investigation, such as HIPAA subpoenas, administrative subpoenas, civil investigative demands, grand jury subpoenas, or search warrants. Cal has a particular focus in the area of healthcare litigation. He represents healthcare providers charged with or being investigated for criminal and civil healthcare fraud and abuse, including violations of the False Claims Act, AntiKickback Statutes, HIPAA, and the Stark Law, as well as Medicare and Medicaid fraud claims. Cal also represents healthcare facilities, providers, practices, and medical staffs involved in third-party payer disputes, utilization review management issues, and medical staff credentialing issues. As part of his healthcare litigation practice, Cal has represented healthcare facilities and other healthcare employers in employment-related litigation alleging violations of state and federal healthcare whistleblower laws, credentialing disputes, and physician disciplinary matters. All that is to say that Cal, our speaker today, is very well qualified to speak on this topic. Cal, we're delighted to have you back to present another webinar. Thank you for all the time that you've already given to BU. I'm going to go ahead. Why don't we get your slide deck up and running? If you could share that from your desktop, that would be great. And then the floor will be all yours.
Thanks very much. I'm delighted to be here. And good afternoon to everyone. It's afternoon here in Boston, so that's what we will go with. We're going to start with a little bit of an overview of the presentation I'm going to give here today. That's going to be on, as you can see, the 4 topics right there: healthcare, compliance, the fundamentals, the who, what, when, and why. Then we will provide, I will go into in some detail, selected healthcare compliance laws, and you can see the 5 that I have selected there. They are the 5 most prevalent healthcare compliance laws right now: the False Claims Act, the AntiKickback Statute, the Physician Self-Referral Law, the Exclusion Statute, and HIPAA. And don't worry if you don't know what those are. That's exactly what I'm here for today, to give everyone just an overview of each of them. The third thing we're going to do is we're going to talk about some compliance risk mitigation strategies. And then finally, we will go through the elements of a compliance program that have been suggested by various governmental agencies. Before we do any of that, though, I do want to address one point, which is, well, who is this really for? And we are going to get to the who of healthcare compliance. But in talking to people in my line of work, so many think that healthcare compliance only applies to providers. And by that, I mean doctors and nurses and physician assistants and dentists and the like. And while it is absolutely true that healthcare compliance and healthcare fraud are critical to those medical providers, it goes far beyond that. For example, medical device companies, pharma companies, diagnostic laboratories, anybody who works in those or with one of those companies needs to know these things and needs to be aware of healthcare compliance and make efforts to mitigate their risk, whether those are the scientists working for those companies, the owners and entrepreneurs who fund them, or even the salespeople who sell those products across the country. All of them need to know these things. So it's not just for healthcare providers. Okay, so without further ado, let's get going on the fundamentals of healthcare compliance. And let's start with the basic question. What is healthcare compliance? Well, it's the ongoing process of meeting legal, ethical, and professional standards applicable to healthcare organizations and providers. This covers a litany of topics, most prevalently patient care, but also billing, reimbursement, and patient privacy, which we'll get to with HIPAA and some of the other statutes. Who is responsible for healthcare compliance? Well, I just talked about all the various professions, obvious and perhaps non-obvious, who need to be aware of this. But who's responsible is a little bit of a different question. The short answer is everybody. Every single person is responsible for their own healthcare compliance. For an organization like a hospital or a medical practice, it is the governing body and the executive officers, and those are the people who are most responsible for it. But really, every individual is and should be responsible for his and or her own compliance. When is healthcare compliance required? Again, let's start with the short answers. Immediately and always. All healthcare providers and organizations need to pay immediate attention to their compliance, but they also need to assess and reassess their compliance obligations on an ongoing basis. We see this a lot. A company will immediately and at the beginning have a compliance program in place and be paying attention to compliance, but compliance is a growing matter. It changes, it evolves with the law, so it requires ongoing attention as well. And then finally, why? Why is healthcare compliance important? Well, there's a number of reasons. First, it does improve patient care. The healthcare compliance laws that we're going to talk about today are there to improve patient care. But compliance also avoids trouble and mitigates enforcement risk by identifying problems and finding solutions. And what do I mean by that? Well, what I mean is money. Individuals and companies that are found to have been in violation of healthcare compliance laws ultimately end up paying a lot of money to get themselves out of it. And sometimes, depending on the conduct, they can even go to jail. So that is at the base, one of the most important reasons why healthcare compliance is important. It's to protect you. It's to protect your companies. It's to find these issues before the government does and be able to address them. Okay, so let's start with the first of the healthcare compliance laws that I want to address today, which is the False Claims Act. The False Claims Act makes it illegal to submit fraudulent claims for payment to the federal government or federal programs. And the False Claims Act we're talking about here today is the Federal False Claims Act statute. This is the most prevalent healthcare fraud statute and the one that is utilized most frequently by federal prosecutors and other investigative agencies to ferret out and investigate healthcare fraud. However, there are also state False Claims Act that are very similar and are used by state agencies. We're not going to talk about them today because this is just an overview and we could spend all day talking about False Claims Acts if we wanted. The False Claims Act is both a civil and a criminal statute, which means violations can be punished by both fines and by imprisonment. And this is not a case where the statute provides for jail time, but it's never used. There are many, many, many people, executives, doctors, practice managers, billing consultants. There are many, many people who are in jail for submitting false claims to the government. And what do I mean? When we talk about submitting claims to the federal government in the healthcare context, what do we mean? Well, what we mean are government payers. We mean Medicare. We mean Medicaid. Those are the big ones, but there are others as well. TRICARE and the Veterans Health Administration as well. Any claims for reimbursement for any medical procedures or medication or services that are submitted to those government payers qualify as a claim under the False Claims Act. So they have to be accurate and they cannot be fraudulent. the last point I want to make on the False Claims Act is that it's a whistleblower statute. And what do I mean by that? Well, it means that individuals are entitled to bring claims on behalf of the government. And that means if they do, and they win, they're compensated with up to 1/3 of the total recovery that the government gets. So for example, if there is a False Claims Act claim that is brought on behalf of the government by an individual, and there are $10 million worth of claims the individual believes were submitted fraudulently, if all 10 million are recovered, that individual stands to be paid more than $3 million for his or her role in bringing the action. And if you think $10 million in claims is a large number, believe me, it is not. There have been False Claims Act cases that have settled for hundreds of millions of dollars, and whistleblowers will get a share of that as well. This is all to say that the False Claims Act is one of the statutes that really incentivizes and encourages individuals to bring these claims. And when they do, these individuals are often disgruntled former employees. They could be even happy employees still working at a practice or a company that knows about some practices that they think are illegal. And the allure of a huge payday or a potentially huge payday for bringing a whistleblower case is just too much to avoid. The FCA is one of the biggest and most effective ways that the government ferrets out healthcare fraud, and this is one of the main reasons why. Okay, the next statute we're going to talk about, the next law, is the Anti-Kickback Statute. And this is a big one. This is a big one in the healthcare context for providers, for medical device companies, and for pharma companies. The Anti-Kickback Statute prohibits the paying of, quote, remuneration to induce the referral of patients or business. Now, what does the statute mean by remuneration? Well, under the AKS, anything at all that has any value can constitute remuneration. And to violate the Anti-Kickback Statute, only one purpose of the payment of remuneration has to be to induce referrals. It does not need to be the sole purpose. It does not even have to be the stated purpose. If any purpose of paying anything of value is to induce the referral of patients or business, you could be looking at an Anti-Kickback Statute violation. The Anti-Kickback Statute, unlike the FCA, is a criminal statute. Punishments include fines, imprisonment, and exclusion from participation in federal healthcare programs. We're going to talk about that a little bit later, but that in many ways is as significant a punishment as the others. One of the complicating factors of the Anti-Kickback Statute is that certain remuneration is indeed protected. And that means that certain remuneration can be paid even if a result or a purpose is to induce the referral of patients or business. Those protected situations where remuneration is allowed are set forth in the safe harbor regulations that are enacted by the OIG. And who is the OIG? Well, OIG stands for the Office of the Inspector General. This is the office within the Department of Health and Human Services of the federal government that is charged with investigating healthcare fraud. So the OIG got together and has enacted many, many, many complicated safe harbor regulations that carve out certain arrangements that do not violate the Anti-Kickback Statute. These arrangements are utilized frequently and creatively by healthcare providers and companies and pharma and med device, but they require some attention, and they require strict attention, because in order to qualify for a safe harbor and enjoy its protections, you have to comply very strictly with all of the requirements, and this can be a very challenging thing to do. Okay, let's talk about the next one, which is the Physician Self-Referral Law. This is also known as the Stark Law. It's named after the congressman who brought it forward, Stark. The Stark Law prohibits individuals from referring patients for certain services to entities in which they have a financial relationship. And let's talk about that last piece. What does it mean to have a financial relationship? We're going to go through some examples a little bit later. But in terms of a financial relationship, under Stark, that refers to both ownership and investment interests and compensation arrangements. And here are some examples. A doctor who refers patients for physical therapy to a physician practice group in which he owns shares, that would be a direct ownership interest. The doctor has a direct ownership interest in the physician practice group, and therefore he cannot refer patients directly to it. What about an indirect ownership interest? Well, that same doctor or a similar doctor refers patients for lab services to a lab that is 20% owned by an LLC in which the doctor has a 5% interest. That would be an indirect ownership interest, still prohibited. What about compensation arrangements? So the example here is a doctor refers patients to a hospital from which he draws a salary as a medical consultant. The doctor receives compensation directly from the hospital and therefore has a direct compensation arrangement with that hospital and could not make those referrals. Indirect would be a situation where a doctor refers patients to a hospital that also contracts with her practice group to provide certain on-call physician services. So in that situation, the doctor is not receiving compensation directly from the hospital, but rather indirectly through her practice group. Nonetheless, that is a compensation arrangement and the referrals would be prohibited by the Stark Law. Unlike the other laws we'll discuss today, the Stark Law is a strict liability statute. That means no intent is required for a violation. The fact that a violating referral occurs is sufficient. And like the Anti-Kickback Statute, the Stark Law carves out certain self-referral arrangements that are permitted. And those, they're not called safe harbors, they're called exceptions to the Stark Law, and they are perhaps even more complicated and more complex than the Anti-Kickback Statute. One of the biggest criticisms of the Stark Law is that the accompanying exception regulations have become so convoluted that they have all but swallowed the purpose of the Stark Law. It is an incredibly difficult statute to navigate and one that we as attorneys get asked about all of the time. Before we move on, I do want to mention one thing. The Stark Law only applies to certain services, and in the law they're called designated health services, sometimes abbreviated as DHS. The statute actually lists what all of the DHS are. So referrals only for those services are prohibited by Stark. And I don't want to get into the details of what is and is not a designated health service today, because that is, as you may imagine, very complicated and very time consuming. But I would encourage anyone interested in the Stark Law to look at that definition. And if you'd prefer to talk about it some other time, certainly feel free to reach out. I'd be happy to go through that. But it's sufficient to say for these purposes today that the Stark Law does not apply to every single service in the medical industry, only certain ones. So before we move on from the Anti-Kickback Statute and Stark, I thought we should give some examples. And as you'll see in the slide, I've given different kinds of examples, and I've labeled them obvious, less obvious, and then hidden. Because when these laws came out, they were intended and did prevent obvious violations. As the jurisprudence and as the law has evolved, so too have the folks subject to these laws. They have become more creative. They have become more developed in how they try to circumvent these laws and the arrangements that are made to get around the AKS and Stark law prohibitions. With that, though, prosecutors and the OIG have also become more sophisticated in identifying these types of arrangements. So let's go through a few examples which I think will hopefully highlight and illustrate these laws. So let's start with an obvious Anti-Kickback Statute violation. It would be where a medical device company makes a cash payment to a physicians every time they use their device in surgery. Classic kickback, classic anti-kickback statute violation. Let's talk about a less obvious one. A medical device company purchases equipment for physicians every time they increase their use of the device. This is one that I have seen. It is less obvious because you're not paying cash. There's not a exact kickback in the form of a cash payment from the device manufacturer to the physicians who are choosing to use it. Instead, that kickback takes the form of the purchase of equipment for that practice. So it's a little bit more hidden. So now let's talk about the most sophisticated example we're going to give where the payment, the kickback is hidden the most. A medical device company hires physicians who use their device as consultants and pays them a salary though minimal or no consulting work is performed. In this scenario, and this is a case I had earlier this year, in this case, the kickback is the consulting payment, and consulting payments are permitted. The problem here is that the consulting payment is not in exchange for any actual work. So the OIG and federal prosecutors will consider that a kickback in violation of the statute, even though on its face the arrangement looks to be on the up and up. Let's do the same exercise with the Stark law. Let's start with an obvious example. A physician owns a diagnostic laboratory and refers all of the patients to that laboratory for blood work. Obvious referrals from the physician to the lab that he or she owns. Very obvious Stark violation. Now let's do a less obvious one. A physician owns 20% of an LLC that owns 50% of a diagnostic laboratory and refers all patients to that laboratory for blood work. So now the physician is still getting some benefit from the referrals, although it's not 100% like it was in the first case, still a Stark violation. And then the most sophisticated, again, pulled right from a case that I had. A physician is hired as a consultant by a diagnostic laboratory to increase volume and refers all patients to that laboratory for blood work. Again, the consulting arrangement on its own is not violative of Stark and would not appear to raise any concerns. It's only when it is linked with the referral of patients to the laboratory where it becomes a violation. So those are some general and fairly basic examples that I think illustrate the two statutes that we've talked about so far. I should mention before moving on that both the Anti-Kickback Statute and Stark are prosecuted by using the False Claims Act, which is the first statute we talked about. If in our first example there with the Anti-Kickback Statute, if a medical device company is paying cash kickbacks to a physician every time they use their device in surgery, every single claim that those physicians submit to the government, to Medicare, to Medicaid, to TRICARE, every single one of those will be considered fraudulent and false. And every single one of them will be prosecuted or subject to prosecution under the False Claims Act, meaning the monetary penalties and the potential incarceration could be very significant. Okay, let's talk about the Exclusion Statute, which is a little bit different than the ones we've talked about so far. The Exclusion Statute requires OIG to exclude individuals and organizations convicted of certain offenses from participation in the federal health care program. And you can see that word requires is underlined, and that's because it's very significant. Very few laws are that black and white. This is a law where there is no discretion granted to the OIG. If an individual or an organization is convicted of the type of offense that is listed in the statute, OIG has no choice but to exclude them from participation in federal health care programs. And let's talk about the types of offenses, because again, it's not everything. This is a summary, and again, I would encourage people who are interested to go and read the Exclusion Statute because it provides a lot of detail and information on the specific types of offenses. But generally, they're broken into these 4 categories. Medicare or Medicaid fraud, if you're convicted of that, you will be excluded. Patient abuse or neglect, felony convictions related to healthcare, theft, or financial misconduct, and then felony convictions related to controlled substances. The exclusion under the Exclusion Statute applies to all federal healthcare programs. That means, for our purposes today, that if you are excluded, you cannot see patients who are covered by Medicare. You cannot see patients that will be covered by Medicaid or any state programs. In Massachusetts, that would be Mass Health. You cannot see veterans who are being treated as part of through the Veterans Administration or through TRICARE. For many people and for many practices, that means cutting their patient population and cutting their reimbursements significantly. I have had clients tell me that the thing they care the most about is not being excluded from the federal healthcare programs. In some cases, that can be the most significant punishment if you're not facing jail time. I have had physicians, I have had dentists who have told me they are willing to pay and are able to pay any monetary penalty, but what they can't have is they can't be excluded from Medicare, Medicaid, and Mass Health, or else they will not have a sufficient source of income. So this is a very significant punishment. It trickles all the way down to individuals as well and organizations. Even if an organization is not convicted of one of these offenses, it is still prohibited from employing or contracting with excluded individuals. All that does is really create an additional compliance obligation for organizations. They have to be able to monitor this and understand and make sure that all of their employees and contractors are okay and not on the excluded parties list. Okay, HIPAA. We're going to talk very briefly about HIPAA today. Because we could, as you all can imagine, we could spend an entire webinar just talking about HIPAA. But we're going to just go over the basics today because it is a critical component of healthcare compliance. So what is HIPAA? HIPAA is a series of standards that healthcare organizations must have in place to safeguard protected health information. HIPAA, make no mistake, HIPAA is a privacy statute. It is a recognition that healthcare providers and laboratories and even some device and pharmaceutical therapeutic companies maintain information about patients that those patients would not want disseminated. And these are the standards by which those organizations must protect that information. So HIPAA, in a nutshell, requires covered entities to do 4 things. The first is ensure the confidentiality of all the PHI they create. And PHI is the acronym used for protected health information. Covered entities also have to identify and protect against reasonably anticipated threats to the security of PHI. This is largely a technical component, making sure that you have sufficient firewalls and encryption and things like that, so that it is not easy for individuals to breach your systems and get at this PHI. Covered entities are also required to protect against reasonably anticipated uses or disclosures of PHI. And then finally, they're required to ensure compliance by their workforce. Make no mistake, the entity, the organization, whether it's a hospital, a medical practice, a laboratory, the laboratory is the first place that regulators look when there has been a HIPAA violation. They are usually the ones left paying the fine and suffering the consequences, even if the mistake is by one of their employees. HIPAA includes both civil and criminal penalties, although I will say the overwhelming majority of HIPAA compliance actions are civil. They will only reach criminal penalties or consider criminal penalties in particularly egregious or intentional situations. The fines for HIPAA violations are significant. They can be up to $50,000 per violation, which can and has been interpreted to be every record, every medical record is a separate violation. So you can imagine if there is a large breach that the penalties could add up very, very quickly. There have been some huge fines for HIPAA violations. In 2018 alone, there was a $16 million fine that a health system paid for a HIPAA violation. In those extreme situations where criminal penalties are considered, HIPAA does provide for up to a year in prison for a violation. Okay, so we've just gone over 5 of what I believe to be are the most important and most prevalent healthcare fraud compliance laws out there, and 5 of the most significant tools that federal agencies and federal regulators and investigators use for enforcing compliance and identifying and punishing fraud. So now let's talk about some strategies for mitigating compliance risks. And this is by no means an exhaustive list. These are going to be just some basic strategies that can and I believe should be implemented by anyone and everyone who is faced with compliance risk. So the first strategy is, I think, the most obvious one, but one that is not always adhered to, and that's creating and implementing a compliance program. In the next slide, we're going to talk, and I'll show you the components of a typical compliance program, including those that have been suggested by the OIG. But the key here is that you do need someone with a legal background to help create and implement this, whether it's an in-house attorney or external counsel. These types of programs do need to be tailored. The most effective compliance programs, as I said, are those that are tailored to the individual compliance needs of the entity or the individual. A medical practice group, for example, is going to have very different compliance needs than a medical device company or even a hospital. Legal counsel, again, either in-house counsel or external counsel, can be very helpful in identifying your biggest risk areas and developing strategies for addressing them. I, for one, have seen the same issues arise over and over and over again in similar settings. I've mentioned a couple of cases today. One paradigm I see all the time is a small or medium-sized medical practice or dental practice who don't have proper billing people in place. They have someone who's been with the practice for a long time. Sometimes it may even be the receptionist or the office manager, and they're the ones submitting and coding claims that go to Medicare, Medicaid, Mass Health. I see this all the time, and those people often are not sufficiently trained and don't have the sufficient expertise to be able to do that. And it is a huge, huge risk area for them and has resulted in some significant penalties. And I can tell you from experience that when you go to the government and try to argue that it's an unintentional mistake, well, they want to know, well, what training was offered to these people? What was the practice doing to ensure that they were doing the billing and coding correctly? And if you don't have an answer for that, they are not going to be very sympathetic. That is an example of a tailored risk area for those types of practices, and one that an effective compliance program once identified would be able to address. Okay, the second strategy is vigorously investigating compliance complaints and issues. This is really important and one that a lot of times is neglected. The whole point of having a compliance program is to identify compliance issues as soon as possible. The sooner you learn about a compliance issue, the better your chances of fixing it are, and preventing it from ever hitting the desk of a regulator. One aspect of a compliance program that we'll talk about is having in place some mechanism for complaints or risks to be reported. When that happens, you have to investigate. It does not help to have a compliance program in place that encourages people to be compliant, to be ethical, and to report things that are out of compliance if you're not going to investigate those issues when they arise. The best practice when you do learn about a compliance complaint or a compliance issue is to utilize outside compliance counsel to conduct the investigation. The reason for this is really twofold. Number one, you want to ensure that the person conducting the investigation has the type of specialized knowledge in healthcare compliance that will allow them to ask the right questions and identify if the complaint is meritorious or not. The second reason that you want to use outside compliance counsel, and perhaps the more important reason, is you want the investigation to be protected by the attorney-client privilege to the greatest extent possible. It's not always possible to cloak the entire investigation in privilege, but you want to do the best you can to do that. One more thing I will talk about with these investigations and why they're important is because if you determine that you do in fact have a compliance issue, one of the things that you're going to want to know is, number one, do I have to report this? Do I have to self-report this to the government? And number two, whether I self-report or not, how can I help myself with a government investigation? And the best way you can help yourself, if the circumstances warrant, is to get what's called cooperation credit. And that's exactly what it sounds like. You want to be viewed by the agency or investigator or regulator who's conducting the investigation as an individual or company that is cooperating with the investigation, with the government investigation. And the way you do that is oftentimes by disclosing what you've learned during your own internal investigation. So, for example, if you are a medical device company and there is a internal complaint that a sales rep is paying kickbacks to physician practices in his or her territory to increase his or her sales, and you learn about that, and you conduct an investigation and determine that that is indeed happening, if the government is also conducting an investigation, or if you self-report to the government and turn over the results of your investigation, including identifying the rogue sales rep, you have a great chance of being viewed as a cooperator and getting cooperation credit and extricating yourself from a potentially very messy, very difficult investigation as quickly as possible. Why, again, we talked about with the False Claims Act how it's a whistleblower statute. That ties in with this as well. Any person in your company or your practice or any consultants or contractors, they are all potential whistleblowers. And if something is reported and learned about internally and not vigorously investigated, you can be sure that whoever reported it eventually is going to get the idea in his or her head that they could make some significant money off of this, and they will bring it to a agency or a regulator or a prosecutor to try to get those wheels in motion, which is why it is so important to investigate promptly, investigate thoroughly, and to take appropriate action based on the results of that investigation. The third strategy, learn about and understand changes in the law and updates to governmental guidance. We talked about this earlier when we talked about when healthcare compliance is important. Remember, it was immediately and always. Healthcare compliance is a changing animal. There are many government agencies, state and federal, that issue guidance and advisory opinions on compliance issues on an ongoing basis. This is not a situation where you only need to check back in when the law itself is amended. That does happen from time to time, and it's very important to know about that. But the law is constantly being interpreted. So even when it hasn't changed, the government agencies that are responsible for enforcing it are periodically issuing guidance and advisory opinions on these issues that will help you and will help give you a glimpse into what their enforcement priorities are and how they view certain arrangements. It's really important to stay up to date on those things, because different guidance and different advisory opinions can change the way laws are interpreted and can give you insight into whether certain arrangements you currently have would be looked upon favorably or not favorably. Given how many government agencies there are out there, this can be a really difficult challenge, which is why it's important to develop a relationship with outside legal counsel. Outside counsel will typically alert you when there are such changes, and they'll help you understand the implications for your specific business or your specific practice. A good example is a healthcare industry association very recently just released some new guidance on cybersecurity. Okay, so that implicates HIPAA. We talked about that a few moments ago. My firm, for example, has a team full of data privacy attorneys who drafted a client alert on the new changes, on the new guidance, and emailed it out. This is a common practice utilized by many law firms to keep their clients updated and make sure they have knowledge and insight into what these changes are. There was another big change very recently where HHS, Department of Health and Human Services, made changes to drug pricing that would eliminate one of the safe harbors under the Anti-Kickback Statute. Again, this is something that we and many other law firms drafted a client alert about and sent it out to all of our clients so they know about the change. That one was extremely significant because there were some clients who were probably utilizing that exact safe harbor in some of their arrangements. And that safe harbor, while not eliminated yet, could be on the verge of extinction. That's something that they may not otherwise have known without having that type of relationship with outside counsel who can help you understand the changes and how they impact your business. Okay. So the last topic we're going to cover are the elements of a compliance program. And this is these elements were set forth by the OIG, the Office of the Inspector General, several years ago. And they identified, in doing so, they identified 7 elements that should be in any corporate compliance program. And we'll talk about what each of those are. The first one are written policies. The OIG has said you have to draft and implement written compliance policies, procedures, and standards of conduct. This makes sense. It makes sense that the OIG would believe they should be written down. That is the easiest and best way to make sure that people know them. But more importantly, if and when there's ever an issue, it's important for the practice or the organization to be able to have something in writing that they can point to say, we trained our people, we gave proper guidance. If they didn't follow it, perhaps that's not on us. So that goes both ways. Number 2, designated compliance personnel. I can tell you this is something that most practices and certainly early to mid-stage companies I deal with do not have. The OIG says you have to designate a compliance officer and a compliance committee who are responsible for monitoring compliance efforts and enforcing compliance standards. I can't tell you how many times I have had a client and I ask them who their compliance officer is and they say they don't have one. And then I say, okay, well, who's the person who deals mostly with compliance? And they send me to their head of sales. That is the absolute worst thing that could happen. And if you don't have a compliance officer, which you should, you ought to have someone who is in charge of compliance and can answer questions and coordinate compliance efforts. 3, training. The OIG is instructed that companies, practices, organizations must conduct effective training and education of its personnel on the compliance policies, procedures, and standards of conduct. So this relates to the first element. It's not enough just to have the written policies. You actually have to train people on them. And we always recommend when you do conduct training that you have individuals sign an acknowledgement form that they participated and understand the training. Depending on your specific business and your compliance risks, it may be prudent to have that training conducted by an attorney, whether internal counsel or outside counsel. I, for one, just conducted some training just last month with a diagnostic laboratory and their sales force, and I'll be doing the same for a company in Pennsylvania later this year. So something to consider depending on your needs. Fourth element, communication. OIG says you have to develop effective lines of communication with your staff, including allowing anonymous reporting. This goes to one of the elements we talked about in our risk mitigation. You want to create easy mechanisms for employees and individuals to report potential problems. They are your best way of seeing potential problems before the government does, and you want people to be able to feel that they have a way to do that and will not necessarily resort to bringing the case as a whistleblower to a federal prosecutor. So effective communication and anonymous reporting, oftentimes it's a hotline or an anonymous website. Those are important elements. Number 5, monitoring and auditing. Another one that's often neglected. OIG will look to see if you are conducting periodic internal monitoring and self-auditing of staff for adherence to compliance policies, procedures, and standards of conduct. Again, this goes to the notion that just having the policies isn't enough. You have to see and make sure that people are following them. So in the example I gave before, if you want to be able to say that it's a rogue salesperson or a rogue employee who is violating your clearly set forth policies, well, then you want to be able to have something to show that you did your due diligence and you did your best to make sure that people were, in fact, complying with the policies and not just reading and forgetting them. 6, enforcement. OIG directs that you strictly enforce standards of conduct for staff through well-publicized disciplinary guidelines. This one I think goes without saying. When you have violations or when you learn through monitoring and auditing of employees who are not adhering to compliance policies, there have to be consequences for them. These should be fair consequences, they should be uniform consequences, and they should be set out in disciplinary guides and followed. Finally, the 7th element would be prompt response. OIG will look to see if the company or practice is promptly responding to compliance offenses and issues that are detected, including developing corrective action plans. That goes hand in hand with enforcement. Again, it's not enough to have policies and to monitor them. There have to be consequences and prompt consequences for people who do not follow them. The reference to corrective action plans is an important one. Corrective action plans are typically written. They're typically maintained in employee personnel files. Those are important to have as documentation and evidence if there is ever an investigation, or if you do ever find yourself or your attorney talking to a regulator or an investigator. It's important to be able to pull out the employee's personnel file and be able to show, look, we identified this person, we have worked with him or her, we have developed a corrective action plan, we have really made genuine good faith efforts to ensure his or her compliance. That will only help you in extricating yourself from an investigation. So that brings us to the end of the slide deck. I don't know if folks have questions or answers, but at this time I'm happy to address them if there are.
Well, Cal, that was, as a layperson, somebody who doesn't spend a lot of time thinking about this kind of thing, that was a really informative talk that you gave. I'll remind our guests, please use the Q&A function to chime in with your questions. We've got a couple more minutes of Cal's time before he'll be back defending some of his clients. Cal, I'd sometimes like to ask my own icebreaker. I'm curious, in your work, working with some of the clients that you have and putting together kind of defenses, how frequent is it that, of the things that you laid out in terms of, compliance programs and monitoring and auditing, are we talking about small practices that are just sort of saying to you like, well, we didn't know. Is that the thing that comes up all the time?
Absolutely. I'm reminded, with that question of a very successful dental practice that I represented in Massachusetts. And it was one of those situations where for years, the person they had was billing certain procedures a certain way, and it turned out to be incorrect. And when Mass Health learned of it, they send what's called, a credible allegations of fraud letter, which basically means, we've analyzed your claims data, we see some discrepancies, we believe this is fraud, and we're shutting you off from Mass Health. And this dentist came to me and said, I had no idea that this was being done incorrectly. Had I known, I would have corrected it. What do I do? And basically what you do is you go to the government and say exactly that. And depending on who you're dealing with, on the federal side, if you're able to establish that you didn't know and that you made good faith efforts to know, but it fell through the cracks, you can typically have a little bit of success there. On the state side, it's almost impossible. Mass Health in particular is very harsh on people, and they don't accept that as an answer all the time. So there are significant consequences for not knowing and for not paying attention to it. Now, I will say that a lot of the standards we talked about, they are on a sliding scale. So a small family practice is not going to be held to the same level of compliance program implementation as a huge multi-state hospital system. But it's a matter of degree, and you have to have something, and you have to be able to show more than anything else that you made a good faith attempt to comply and to ensure your compliance with these various healthcare fraud statutes.
Let's look at this from the other angle for a second, knowing that your primary role has been in helping organizations get their act together, stay in compliance, that kind of thing. If we have somebody on the webinar today who works at a practice or a business that they have suspicions that things are not on the up and up, that violations are happening, and that maybe even there's something malicious happening, a doctor really trying to sort of get away with something, what should that person as a potential whistleblower do? Is it call Cal Stein, or are there other resources that somebody should seek out?
So the first thing they should decide is whether they want to raise the complaint internally. And if your company has a policy and a mechanism for raising it internally, that is something you may want to consider. That would be the first option. If the person wants to pursue a whistleblower claim, those people, you're either called a whistleblower or a relator, and the name of the suit is usually referred to as a qui tam or a qui tam suit. And there are attorneys out there who that's all they do, is represent individuals in these qui tam whistleblower lawsuits. Unfortunately, that is not me. I don't handle those types of cases, but there are attorneys out there who do handle them, and often handle them on a contingency basis, which means you don't have to pay a large hourly fee to pursue the case. So those would be the kind of two decisions to make. Number one, do you want to pursue it internally? And number two, what type of qui tam attorney do I want to go and find?
Well, we've run up against the hour, and Cal, the other questions that have come in have been quite individual in nature, and I'm going to encourage people to follow up with you directly. I know you were going to plan on sharing this contact info, what are the types of questions that you can help answer if people need to get in touch with you?
Yeah, I appreciate that. And certainly I would encourage everyone on the webinar or anyone listening to it, down the road. If you have specific questions, my contact information is on the screen right now. You can always reach out. If you'd like a copy of the deck, you can certainly reach out as well by phone or by email. I'm happy to talk with anyone about any concerns they have. And the ones that are typically very specific, what should I be doing with this? My employee just complained about X practice. Is that a violation? Those are the types of calls I get all the time. And I am always happy to speak with people about it. Consultations or conversations, I always treat them as confidential, so that's not something you have to worry about. But I always encourage people to reach out with those specific questions, because something small or something you think is small could end up being rather large. And it's always good to get a different perspective on it, and from someone who understands the healthcare compliance laws and what a regulator might do with that if they learned about it. Not every single violation is something that's going to be an enforcement priority, but some things that might seem small are often enforcement priorities. So those kind of practice or individual specific cases, I would encourage you to either reach out to me or someone else to discuss it, and I'm always happy to do so.
Cal, you've been a huge help for the BU alumni community. As we mentioned, this is you've done another webinar for us. You did a great session about sort of the basics of contracts. So for anybody who in their role has never been trained on what to look for in a contract, that kind of thing, you can find the recording of that webinar on our website at bu.edu/alumni. Cal, I want to thank you again for everything that you've done for BU and for doing this presentation today.
My pleasure. Thank you all for listening, and I appreciate the time.
I will also join Cal in thanking you all for logging in. I want to thank those of you who've donated to BU in the past. We couldn't do the work that we do without you. I want to make sure people know, as I mentioned earlier, today's webinar is part of our annual series called Alumni Career Weeks, where we've got webinars and in-person events happening for alumni networking around the globe during the month of March. I encourage you to visit our website at bu.edu/careerweeks to see the full schedule of events that are happening, and to go ahead and sign up for some of the other webinars we've got coming up during the month of March. As always, if you or any BU alum would be interested in doing a professional development or industry insiders presentation like the one that Cal did today, I'm always looking for great volunteers from the BU alumni community. So please feel free to contact me at the Alumni Relations Office or by email at jtmurphy@bu.edu. Thank you again, Cal. Thank you, everybody, for joining us. I hope you have a great day or a great evening wherever you might be.